and welcome to another episode of Frankie Meatballs Says. I am your host, Frankie Meatballs. Today's show is brought to you by No Itch Suppositories. Just insert one suppository in your pooch's back end, and No Itch will take away that bitch. Don't let your itch be a bitch. Try No Itch Suppositories. Today we are going to talk about the mediation process. This is the time that the parties attempt to settle the case. They do this with the assistance of a mediator. A mediator is someone who oftentimes is a lawyer or a retired judge who hears both sides of a case and tries to get the parties to work out their differences so that the case can get resolved and everything is over. It can be at either attorney's office or sometimes it's at a neutral location like the mediator's office. Depending on the value of the case, sometimes the adjuster who has the authority to resolve the case will appear live, and sometimes they'll appear by phone. Ordinarily, if the adjuster does attend live, it's the first time that he or she has an opportunity to see you. So you need to present yourself as a respectful, nice person who looks like someone who will gain sympathy from a jury. Number one, you should dress appropriately. Slacks and a pullover or a conservative outfit are just fine. You don't want to be too flashy with a lot of bling. You also don't want to wear t-shirts with a picture of a pot leaf on it. Those are no-nos. But you also don't have to wear a suit. The mediation begins with the mediator explaining the purpose of mediation and the goal. After that, the plaintiff, through his or her attorney, get to present an opening statement, where they will discuss those three cherries that I told you about in earlier episodes. First, there will be a discussion about the liability portion of the claim. That is, how the incident occurred and why it is the other side's fault based on the facts of the case and the law. Next, the attorney should describe in detail the specific care you received for the injuries you sustained in the incident. Your attorney will describe what kind of treatment you will need in the future over your lifetime for those injuries as well. And he'll lay out what the estimated costs for your future care and the actual charges for your treatment to date are. If you have missed time from work due to your injuries, the attorney should address what type of lost wages you have incurred. If your injuries prevent you from going back to the same employment you had before the accident, there will be a discussion on your loss of earnings capacity and the value of your future lost wage claim. This is usually supported by an expert like an economist. If you incurred out-of-pocket expenses due to this incident, your attorney should address this too. These are called your economic damages or compensatory damages. Next, depending on the severity of your condition, your attorney may address non-economic damages in the opening statement by discussing the pain and suffering you have endured and how this incident has and will impact your quality of life. Many times attorneys will not have a discussion about non-economic damages like pain and suffering in the opening statement, but will still place a specific value on it as part of your settlement demand. Depending on how egregious and reckless the defendant is in this incident, the attorney may have filed a claim for punitive damages, which is an amount of money he or she is seeking to deter repetition of this in the future. Excuse me. Usually this occurs when there is a claim for gross negligence, such as when there is evidence that the at-fault party was intoxicated at the time of the incident or was texting while driving at the time of an accident. After the plaintiff's attorney has given his or her opening statement and provides a settlement demand dollar figure, the defendant or alleged at-fault party's attorney gives an opening statement. Sometimes they will deny any liability whatsoever. When that happens, it's very hard to resolve a claim at mediation. But sometimes the attorney will place only a percentage of fault on his or her client and claim there was comparative fault on you, the plaintiff. Sometimes they will agree that there's 100% of the blame that should be placed on their client. No matter what they claim, the next area for discussion are damages. They will argue that the treating doctor's charges for their services are overinflated, and their expert is going to say that the value you are placing on your present medical charges and future care is way too high. They will also try and discredit the lost wage claim and loss of future earnings. Their main function in their response is to show that they value the case a lot lower than you do. After the other side gives their opening statements, your attorney will have an opportunity, if he or she wants, to respond briefly to any points that she wants to make about their statement. Usually, these comments are restricted to inaccurate information. The goal of the opening statement is for the mediator to have a good picture from both sides as to how each party is analyzing their case. Sometimes mediators require a written statement from each side a few days before the mediation, similar to a settlement demand letter we send to an adjuster before a lawsuit is filed. Once the opening statements are finished, each party separates, and the mediator goes from room to room with counteroffers and counterdemands, while giving each side useful information about the weaknesses and strengths of each other's cases. The best way to describe a mediation is as follows. Pretend you are at the Empire State Building. Your first settlement demand is as if you were at the penthouse. Their first offer is as if they were in the lobby. Both parties go into different elevators, stopping at different floors along the way, which is equivalent to counterdemands and counteroffers. At the end of the mediation, if both sides were on the same floor, you shake hands and you have a successful mediation. If you are on different floors, well, the mediation is not successful, and your next step is to typically go to trial, or oftentimes it's a crapshoot. This is Frankie Meatballs from the Dickstein Law Firm, signing off. If you have a question regarding your accident or injury claim, call the Dickstein Law Firm at 954-893-8000 or 888-FLA-HURT, or visit our website at flahurt.com.